This is a version of the talk that I gave yesterday, April 5th, at the Fordham Intellectual Property Conference. The topic is my recent paper, Access in the Public Domain. So when I start copyright, very beginning of the class, I start with a blank piece of paper. And we spend some time talking about the property rules that apply to that piece of paper. Those are the rules of physical property. Those rules have, when you think about the range of kinds of things we bring to bear, very complicated, sophisticated rules for real property with elaborate title systems and recordation systems. If you remember first-year property, fee tails, all sorts of remainders and possible ways of slicing and dividing those interests. We tend not to do that for, excuse me, smaller items. We certainly don't do it typically for pieces of paper. We have a sense of the ownership regime, and we sense of who gets to control access to that piece of paper, and that's the owner of it. I then pull out a pen and perform what I think of as copyright magic, or the miracle of copyright. I compose a poem live in class. And that poem is inevitably a very bad poem. But that actually sort of serves my purpose. Unlike patents where we have a filtering system, an often criticized filtering system as to who gets a patent, where you have to get through some test, there is no Bureau of Copyright waiting for my poem in Washington to see if it's good enough to qualify for a copyright. We know instead that in copyright arises immediately. Original work of authorship, fixed in a tangible medium of expression. That's what gives rise to a copyright, and nothing more. It has to be original, created by me, original to me, but the quality of the poem is irrelevant, and the poem I create on the first day of class is always original to me. The miracle of that, or the copyright magic, is I've now created this thing, which now is entered into the copyright system. I've added another layer of law, property-type law that applies to it, where now I have something where the copyright statute tells me I control the use of that pursuant to the terms of the Copyright Act for the life of the author plus 70 years. That's really quite remarkable. And once we've completed that discussion, then we switch back to the physical property regime, because the paper still, in the instantiation of the work I've created, still exists within the physical property regime. And those rules haven't changed. It's still a piece of paper. I still get to control access to it. So as we think about what we're doing when we think about the public domain, one of the things I think it's critical for us in terms of organizing our thinking is this distinction between use rights, which typically arise in the copyright system, presumably have very little application to works that have entered the public domain, and access rights, which exist in the non-copyright system, in the personal property system, in the physical property system, and then in other systems, where even for works that are in the public domain, those are going to be embodied in something, and the rules that affect things that are those embodiments, those are the rules we're going to have to consult and have in mind. And the purpose of the paper and the purpose of a talk is in some sense to surface those rules. All right, what I'm not talking about, just to be clear though, so there is a broad movement to increase access to knowledge, and the White House is in some sense participating in that through its recent announcement, where it hopes to expand access to works that are funded by federal dollars. Those are going to be in copyright works, but that's not what I'm talking about here. My focus here is on the public domain and not works in copyright. All right, why did I write this paper? Well, I wrote a paper a couple years ago on history of razors and blades. I've had an ongoing interest in these systems of connectivity, and razors and blades is an example of that, and obviously in some sense a classic example, and we think well understood example. I think that turns out to be wrong. I think if you go back and look at the history of razors and blades, it's much more interesting, much richer, and the conventional wisdom doesn't really capture what happened when King Gillette, that was his name, when King Gillette acquired his initial patents on the handle and the razor blades that went in it. But that's a different talk. What's interesting for our purposes is that in doing that paper, I wanted to include some of the images of the day to give readers a much more concrete sense of exactly what was going on. And for me, I looked through Google Book Search for some of these images. And Google Book Search will be part of what I want to talk about here. As you can see, this is from the Yale Literary Advertiser in May of 1889. One of the celebrities of the day, at least a Yale celebrity, or Harvard celebrity, Dr. Oliver Wendell Holmes, describes the virtues of what he sees as this razor. When I wanted to include this image in the paper, you start with the fact that the underlying work, the Yale Literary Advertiser from May of 1889, is clearly in the public domain of the United States. And so it should be straightforward to include it in my paper. There is a question, though, about the scan of that image. Is that something that's a new thing? And there's a question as to whether that new thing, what controls that? Now, Google didn't think that there were any copyright issues associated with the use of that image, and I blithely went forward. In contrast, here's a second image. This is from, as you can see, the New York Times in 1904. Again, the New York Times of that date is in the public domain of the United States. This image I could not find in Google Book Search. Instead, I found it on ProQuest's wonderful historical newspaper database. ProQuest would never send us a letter, but my understanding is that ProQuest believes that their scans are in copyright. But they have in some sense photographed the underlying documents, underlying works, and that those photographs, like many photographs, most photographs, almost all photographs, enjoy copyright protection. Copyright is original work of authorship, fixed and tangible in expression. Now, I disagree with that, and I know lots of people who do. The question is what would be original here in this context? And I talk about that some in the paper, but I'm not going to focus on that issue here. In any event, we found a paper copy of this, made our own scan, and that's what appears in the article. So this question of what are the tools that control this public domain that's rolling out in a big way, the rollout of the public domain, practical access, the possible practical access is actually incredibly exciting. But there is this regime of control over it, which may be perfectly sensible, but I think is underappreciated. So go to Google Books and run a search. I searched on Alice's Adventures in Wonderland. And as you can see, the top search result there indicates the book by Lewis Carroll, an 1869 edition. That looks promising. Anything before 1923 in the United States is in the public domain, so we might hope that we could get that book. Indeed, that's what you find. If you go there, Google offers a number of ways of getting it as an ebook for free. I chose the PDF, and I get the book. Well, not quite so fast. As you can see, Google implements a technological protection measure designed to ensure that mass downloads don't take place. They ask me to prove that I am human and not a robot by typing a CAPTCHA. And that's what you do. You type it in, and then lo and behold, you can download the book, which is what I did here. That is indeed the 1869 edition in the public domain. As a public domain work, we can do whatever we want with it. But if you look at the very first page in the file, what we find is actually a letter from Google to you, the downloader. And as you can see, Google offers what it describes as usage guidelines. Google gives you some sense of where you are, what Google has done in bringing these digital works to you. Google recognizes the value of the public domain, the way in which it links culture over time. And Google's happy to play the role of a custodian, as it describes it, for the public domain. Sounds great. It's all good. And then with one word, the document takes a slight change of course. Nevertheless, says Google, nevertheless what? Nevertheless, as we know, actually doing the work it takes to put a digitized version of the public domain in front of us is hard. It's expensive. It involves lots of organizations and lots of technical know-how. It's expensive. And given that, Google wants to protect its investment. That's hardly surprising, and there's absolutely nothing wrong with that. So it takes a number of steps, including technical steps that it describes here, and then, well, steps like this first page to the download to try to set the terms of use. What are those? Well, Google asks, and ask is always a funny word. It doesn't demand, it doesn't, so who knows where we are? Is this a contract, something different than that? Non-commercial use. So if you come up with a great use of this book that will make you a lot of money, don't get the book from Google. We've already mentioned that Google is very much concerned about the possibility that one of its competitors will seek to free ride on the work that Google has done. So no automatic querying. And Google wants to be acknowledged for the work that it's done. Attribution. One of the classic examples of a moral right. Well, these limitations, while quite understandable, and in many ways perfectly sensible, are not universally loved. And in the last Digital Millennium Copyright Act rulemaking proceeding, the anti-circumvention rulemaking proceedings, as they're known, which take place every 3 years, a group came forward and asked the Copyright Office to consider doing something about Google. In particular, the Open Book Alliance, which includes the Internet Archive, Microsoft, and others, came forward and said, Google has imposed limitations on the libraries that it partnered with to come up with the books that Google has digitized for Google Book Search, including those in the public domain. The contracts, or at least some of the contracts that Google entered into with these libraries are public. Some of these are public institutions, obviously, like the University of Michigan, and are quite detailed. There's no doubt that these are contracts. And those contracts impose a variety of restrictions on what the home institutions, the home libraries, can do with the digital copies that they've received back from Google. The Open Book Alliance has a perspective on that. It's wrong, that's what they say, and Google shouldn't lock those up. And what the Open Book Alliance asks for then, as one does in the rulemaking proceeding, is an exemption from the general scope of Section 1201. And 1201 generally limits the ability of individuals or firms to circumvent technological protection measures of the sort that Google seems to have imposed with regard to its Google Book Search database. The only issue here is the precise coverage of Section 1201, which, as you can see, 1201 is actually limited to works protected by this title, which is the copyright title, to works in copyright. So works in the public domain aren't seemingly protected by 1201. That means that 1201 doesn't, there is no violation of 1201, presumably, if you circumvent a technological protection measure protecting a pure public domain work. At the Fordham conference, that's exactly what David Carson said was the interpretation of 1201 that the Copyright Office had offered originally. That's what I say in the paper, and it seems like the only natural reading of 1201, notwithstanding the Open Book Alliance's request. That's exactly what the Copyright Office found here. It didn't have the power to create an exemption. No exemption required, no exemption could be given. And so to the extent that the Open Book Alliance hoped that they would be able to create a safe harbor with regard to whatever acts, technical acts, they want to take vis-a-vis the Google Book Search database. It's not the DMCA rulemaking which is going to help them. Let's try a second example. So JSTOR is beloved by academics and has done JSTOR is a nonprofit organization which has digitized millions of mainly academic work, published articles, most of which are in copyright, but as you see here, JSTOR says 6% of which are not in copyright or in the public domain. You'll note the date here of the early journal content slide. So as of September 6th, 2011, JSTOR undertook a new program to make the public domain more generally available. Now this came after a set of events involving Aaron Swartz, and the reason this is now so much more prominent is that eventually at the end of that path, Aaron Swartz committed suicide, and that's given these issues a much greater public attention. JSTOR's materials comes with a contract, terms and conditions of use, which I think numbers in the range of 7,800 words. So it is a sizable contract, and even the early journal content material that is in the public domain comes with a smaller contract, which, again, much like the Google cover letter or cover ask, restricts the use to non-commercial purposes and bars automatic, robotic type querying and downloading. JSTOR, too, wants credit for what it has done. As I mentioned briefly before, Aaron Swartz thought that JSTOR's restrictions on its downloads, its digitized works, were unacceptable. And he has online, or had online, a manifesto in which he details his views on the moral importance of open content. And beyond just writing a manifesto, Swartz set out to implement that, seemingly, or at least so the federal government alleges in the indictment that you see that was filed on July 14th, 2011. There is a second superseding indictment, but I'll focus here on the original indictment. As you see, that indictment charges Swartz with a number of crimes. Wire fraud is a very broad, the applicable statute is a very broad statute. The Computer Fraud and Abuse Act is really what I think is particularly interesting here and has received so much attention after Swartz's death. The Computer Fraud and Abuse Act, the first time you read it, you are struck by its possible breadth and its lack of clarity, and that's something that one should find troubling, or at least possibly troubling in a criminal statute. Though, as you read through the indictment, if the facts are as the government alleges, and who knows what the actual facts are, Swartz undertook a substantial effort to download material from JSTOR, and engaged in a series of acts which he should not have been surprised to find, it seems to me, that the government thought those were worthy of investigation. Again, I don't know what the facts are, and now seemingly we're probably likely never to know them fully. Where does that put us? Well, what we've seen so far is that there are a variety of non-copyright measures by which the public domain, which is coming online, will seemingly be controlled. Those include contracts and terms of use, technological protection measures and possibly statutes protecting those. It includes things like the Computer Fraud and Abuse Act. And I think there will be a natural incentive and an understandable incentive for firms that are investing substantial resources in creating these digital works to want to make sure that they've got a financial structure which protects those works and protects their investments in those works. If we want a truly public domain, we probably need to look elsewhere. And that's going to be something perhaps like the Digital Public Library of America, which is rolling out, or something perhaps done by the government, the Library of Congress or something like that. So what should we take away from this? Well, I'll go back to where I started. I think it's very important to distinguish these idea of access rights and use rights. I think we slide over that distinction. The copyright system is a system which is based on what you can use works for when you have obtained legitimate access to them. Copyright itself does very little, says very little about how works are accessed, and the access regime is what's going to be at stake with regard to public domain works. How do you get access to, what are the terms of access to either the physical works in which a public domain work is embodied or in the digital version thereof? Very different regimes. We're at exciting times for the practical availability of the public domain. That's really tremendously exciting. In some sense, the public domain has been obscure and hidden in libraries that can be hard to access. An online public domain is really very exciting. At the same time, understandably, people spending lots of money doing this want to protect their investments, and those are going to result in use restrictions that I hope I've successfully sort of described here, and that will be complicated and may trigger situations where the applicable statutory regime didn't necessarily have these kinds of settings in mind. If we want a real public domain, we're going to have to go down a different path. And that's going to require, I think, public financing. Possibly something like the Digital Public Library of America. But that is the road maybe we're starting to take with regard to creating a public domain. Thank you.